Hello, dear students. Yes, the timetable for the examination is already out. Hope you have seen it in the WhatsApp groups where I have shared it or have already downloaded a copy of the same from the university's website. Well, all the very best for your preparations. I am Dr. Vibha Sharma, Associate Professor in Government Law College, Ajmer, with my fourth lecture on legislative drafting. This video is in continuation of the video on the principles of legislative drafting that I had earlier uploaded on YouTube. I have actually shared the link of the first video in the description box for the convenience. So let's start with today's video on principles and techniques of legislative drafting. So after having shared with you all the general principles and techniques of legislative drafting, in this video, I would be discussing some of the particular principles of legislation. So I would start with the evolution of principles of legislation. The evolution of thought on legislation began from the time of the Renaissance and the Reformation, when men actually turned away from the rule of custom and tradition and took legislation as an instrument of social and political change. Thereafter, many thinkers of 18th century began to formulate principles of legislation which were to govern the laws that men could make for themselves. So here we will just consider the contributions of some of the thinkers in formulating the principles of legislation. So first of all, Richard Hooker, who was an ecclesiastical thinker. He strongly believed in law of nature and of a reason of human life. Then Francis Bacon, a famous thinker, he postulated that the security of the people is the supreme law of the state. Then John Locke. I hope most of the names will ring a bell with you because you already have read them in jurisprudence or in criminology. So John Locke, he actually was a propounder of a glorious revolution from where the modern history of legislative principles started. And he actually said that the first and fundamental ideas of law and legislation was that the legislature is the first and most important maker of law, and the object of law is to respect the right to liberty and property. And he also said that above all, laws must be made for the good of the people. Then, of course, we are very well aware of Montesquieu, a great political thinker who actually has written Spirit of Laws, and we know him because of his doctrine of separation of powers. He actually had the main idea that there are three organs in any state: the legislative, the executive, and the judiciary, and progress of a government depends upon the independent functioning of these organs. So this doctrine of separation of power actually led to greater activity and efficiency of the legislature besides independence of judiciary. Then we come to Beccaria. We know him as a great criminologist, and he advocated a revolution in philosophy of punishment. He actually humanized criminal law, and he was the greatest proponent of the natural rights of human beings. Then, who doesn't know Blackstone? He was an English jurist, and of course, he advocated the freedom of person and property. Thereafter, we have Plato, Aristotle, Thomas Aquinas, etc., who actually gave many theories in relation to good and useful legislation. And then we come to Jeremy Bentham, the greatest reformist of his times. We may say that he was a philanthropist also. I hope you already have read much about him already. Anyway, so Jeremy Bentham, he wrote a book, Introduction to the Principles of Morals and Legislation. It was published in 1787. And he is the one who actually propounded this theory of utilitarianism. That is, the public good ought to be the sole object of the legislation. Okay. Now coming to Edmund Burke, on this slide, I actually have brought out the summary of his theory, what he actually held as far as the principles of legislation is concerned. So he was one of the proponents of equality before the law. And he also said that nobody has a right to make any law he pleases. No law can derive their authority from the Constitution merely and independently of the quality of the subject matter. And he also said that all laws must conform to the rule of justice. I hope that we all are aware of the difference between law and justice. And then he says bad laws are the worst kind of tyranny. And lastly, that lawful enjoyment of rights is the surest method to prevent unlawful gratification. Okay, so here we will go through some of the principles of legislation which emerged towards the end of the 19th century. And then we will take some of the particular principles which we find that actually were formulated over a period of time. So just going by these principles one by one, that is, laws should be known to be obeyed. Application is necessary. Laws should answer expectations. A part of it contained in legitimate expectation and administrative law. I hope you are already aware of it. Then, laws should be consistent with one another. Laws should serve the purpose of utility. Laws should be methodical. Laws must be certain to be obeyed and must not become a dead letter. Then, laws are necessary to ward off the danger of the operations of egoism or self-interest, which are the ordinary motives of human actions. And of course, that the laws and legislations must aim at justice, which suits all. I hope we already are aware of the difference between law and justice. Then, law is a means to an end. We already know it. Then, security of the people is the supreme law of the state. Public good ought to be the object of legislation. And last but not the least, all laws must conform to the rule of justice. Okay. Now, moving on to the particular principles of legislation. So now we come to individualism as principle of legislation. The term individualism as principle came into being in 1835. This is a social theory which advocates the free and independent action of the individual. Now, the theoretical foundation of individualism is actually the recognition of the autonomy and the absolute rights of the individual in society. Now, this doctrine rests on the conviction that the preservation and development of each human personality represents the sole justification and purpose of the state. Now, the original concept of individualism as propounded by Stoics emphasized much on the importance of human mind and spirit. But this concept was transformed into an economic individualism in the 19th century. So the individualism which to John Stuart Mill meant the right to think, speak and worship freely became the right to buy, sell and manufacture without social or government control to Adam Smith. Okay. Now, without going into the very many details of this principle of individualism in sociology, we would just say the working of this principle of individualism in legislation. So we already are aware of that celebrated characterization of legal development by Sir Henry Maine in Jurisprudence Historical School. I hope all of you remember that particular statement that he made, a powerful one indeed, and that was that the movement of the progressive societies has hitherto been a movement from status to contract. So, of course, we all are aware that status of an individual in traditional society actually was derived from membership of class or group, which was institutionalized by law rather than choice. And then when the society moved towards this principle of individualism, the freedom of contract was very much in place. Now, Blackstone, in his commentaries on the laws of England in 1765, wrote that the first and primary end of law is to protect the absolute rights of individuals. He actually reduced them into the three categories, which were the right of liberty, the right of personal security, and the right of property. Now, as far as the freedom of contract is concerned and its impact on individualism and legislation, so we actually have seen the maturation of individual civil rights as habeas corpus, trial by jury, freedom of contract, the freedom of press, etc. So we are very well aware that these are some of the reflections of individualism as applied by the legislature. So, without doubt, a great change for individuals actually represented in law, which was evidenced by the advent of freedom of contract. So now we will move on to the principle of utilitarianism. So now coming to this theory of utilitarianism, which was propounded by Sir Jeremy Bentham, about whom we already have read under jurisprudence. He was a great philosopher, reformist, philanthropist, as well as a jurist. And this theory of utilitarianism, which was propounded by him, remains relevant till date. So what Bentham actually expected from each legislator was that he or she should strive for the greatest happiness of the greatest number of people. He detailed the sympathies, antipathies, and listed the pleasures and pains of a human life. And without going into those many details, we would just go through some of the objects of civil law, according to Bentham, were to guide the legislator to distribute rights, which he said were pleasures, which the legislator confers, and the obligations which he imposes. And according to Bentham, the principle of utility guided the legislator to never impose a burden or pain except for the purpose of augmenting pleasure or happiness for greater value. And according to him, the ends of civil law were subsistence, abundance, equality, and security. Of course, he laid a lot of importance on this end, and that is security. According to him, if security is not there in a society, then one will not be able to provide for his or her subsistence, will not be able to have abundance, and of course, equality will not be possible in such a society. As far as the criminal law is concerned, he actually said that the extensive object of criminal law should be to prevent, as far as possible, all sorts of offenses. And he actually held a belief that the legislator's aim should be that no offense be committed. He also knew that people would actually be committing some of the offenses, and but according to him, he said that it is the duty of the legislator to induce a human being to commit an offense which is less mischievous, so that the mischief is kept down. And suppose somebody commits a particular offense, then he proposed that it should be prevented as cheap a rate as possible, because he believed that punishment in itself is evil. But of course, again, he lists all those possibilities and actually beautifully lays down all those aspects which would cover the area of criminal law very adequately. So in case you have time in future, please go through the principles of legislation, which actually have been edited by uh, Upendra Bakshi, and the principles of moral and legislation by Bentham would actually be a great read if you have time. Just go through these books. So, in his introduction to Principles of Morals and Legislation, which was published in 1787, he has brought out in great detail the theory of utilitarianism. But of course, some of the jurists also feel that there have been variations in the manuscripts which he actually had written. So anyhow, now moving on to the last aspect of these principles of legislation. So now coming to this final aspect of the principles of legislations, and of course, it is none other than the directive principles of state policy, which we can very well say are the values which are contained in the Constitution, especially in the Indian Constitution in its part 4. So most of the countries who have the constitutions in place have got these directives, and these directives are generally actually for not only the legislative organs of the state, but they're also for the executive. And these directives work as the guiding principles to the future legislature, because they actually show that in which manner they should exercise their legislative power, right? Now, such directives are clearly concerned to achieve the philosophy of welfare state. And of course, we know that in the Indian Constitution, all these directive principles of state policy are contained in Part 4. All those DPSPs actually aim at social welfare, common good, and also expect that the legislature, while enacting any law, would strive to secure to all citizens economic and social justice. So we already have seen as to what all laws have been enacted under the various articles contained in Part 4 of the Indian Constitution. So now I really hope that all these principles have given you an idea as to what is expected from legislatures and the drafters, that while drafting legislation, what all is to be kept in mind and the guiding principles which they should consider. So all the very best for your exams, and I really hope that these videos of mine are actually helping you in understanding the legislative drafting aspect of the paper which is there in your course. So all the very best. Take very good care of yourselves. Thank you.